You're welcome to this video where we speak about vicarious liability, as you saw. What is vicarious liability? Let me illustrate it this way. Auntie Ama is a food seller. Let's say in the village we call Mimpasem. Now, close to where Auntie Ama sells her stuff, she sells some fish. There is a little boy, Kwame, who after school usually plays with his friends, soccer, nearby. Now, on this particular day, as Kwame and his friends were just playing around, he kicked the ball, and his ball just went and fell straight into Auntie Ama's soup. Feeling scared and afraid, Kwame ran away. In a little community, what do you think Auntie Ama will do? I'm sure your guess is as good as mine. After not finding Kwame, Auntie Ama may decide to go to Kwame's house and probably report the matter to Kwame's father or mother. The reason? He feels that, or she knows, that Kwame has got parents, and these parents are the ones who care for him. So if he has done something wrong, and she's looking for someone to report the matter to for quick action or any remedy of a sort, she would go and report to her parents. So she does that and tells Kwame's father. Kwame's father, Eja Kwabna, is saddened by the story. So what does he do? He picks up his wallet, dishes out some money, and gives it to Auntie Ama and apologizes. I'm sorry for what happened. It is a common occurrence. Now, when we elevate this into the private rights of individuals, you, me, governments, and institutions, that is much of what we mean by vicarious liability. Now, in vicarious liability, in this illustration, you may realize that you have an individual A, another individual B, then the third individual C. Now, A is held liable for some harm that C has suffered. And C suffered that harm because it came from B. And A has to fix that harm because A is related to B in a way. So if we connect it to the Auntie Ama situation, let's say Auntie Ama is person A, Kwame the young boy is C, then Kwame's father is B. Okay? Because of the relationship in there, it generates what we refer to as vicarious liability. So now let's succinctly define it. What is vicarious liability? The expression vicarious liability signifies the liability which A may incur to C for damage caused to C by the negligence or other torts of B. You saw that. So that is what we mean by vicarious liability. You have three individuals. We are saying, in simple terms, that if there is a third party who suffers a certain bit of harm, okay, and there are two initial parties, A and B, by virtue of the relationship between A and B, if C were to suffer some harm at the hands of B, C will hold A responsible. So Kwame is B, his father is A, Auntie Ama is C. Auntie Ama has suffered as a result of the actions of Kwame. That is, C has suffered as a result of the actions of B. But because of the connection of A and B, C doesn't just hold B liable, C also chooses to hold A liable. So Auntie Ama chooses to hold Kwame's father liable. That is how come she went to the house to go and complain. So broadly, or in simple sense, that is what we try to mean by vicarious liability. It may happen in so many ways. Now, much of the focus in this video, and particularly also for the exam, is that you can have these situations of vicarious liability arising out of employer-employee situations. That is, if A is an employer and B is A's employee, if C were to suffer some tort out of the negligence of B or some other actions of B, C can choose to hold A responsible because of the actions of B. That is what we call vicarious liability. So sometimes certain actions that an employee may do, a third party who is affected by that employee will hold the employee's boss responsible. Again, we say that is what we mean by vicarious liability. I hope it's clear. All right, so now we move on to the next step. That is the elements of vicarious liability. What do we need to observe, to look out for in a situation where there has occurred a wrongdoing? Someone has suffered a harm. A third party has suffered a certain tort. And this particular tort that the third party has suffered, he wants to hold another person vicariously liable. What are the elements that should be present? Let's consider the elements of vicarious liability. The first element that we'll look at in establishing a vicarious liability, that is trying to hold a person vicariously liable for an action, that is a third party is trying to hold the first party vicariously liable, is number one, the nature of the relationship between the first and second party. What is the nature of the relationship? Now, the common law position or the position of the law is that, one, there should be a master-servant relationship between the first and second party, or what we call A and B. If A and B have a master-servant relation and C suffers out of that, we can say that C can hold the master responsible. So for the employer-employee relation, if the employer is the master, the employee is the servant. So once we're able to establish that this man is the employer or that company is the employer, he is an employee. Anybody who should suffer at the hands of that, we can now look out for the element of vicarious liability. Now, we look at the authority in a very old common law case. The case is Ewens versus Noah case. Now, the Lord Justice in that matter gave a definition of what we classify a servant, or how we can look out for a master-servant relation. See what was said in Ewens versus Noah case. Per Bramwell B, a servant is a person who is subject to the command of his master as to the manner in which he shall do his work. Did you notice that? So the first authority that we try to look out for, again, in a vicarious liability situation is when we want to see the nature of the relationship between the first and second party, a master-servant relation. The court said that a servant is that person who is subject to the commands of his master as to the manner in which he does his work. So the first requirement that we look out for an element in trying to establish a vicarious liability is, if between A and B, the relationship is such that A effectively controls the actions of B, we have a master-servant relation. If the way B goes about his work, the manner in which he does his things, the instruction that he takes, how he is cared for, and all the connections and controls over his work is principally controlled by A, there exists a master-servant relation. When that is established, the first element of vicarious liability is proven in that. But you see, sometimes control may not necessarily be that strict, but still there will be some kind of connection in there. That also gives us an additional way to also establish the nature of the relationship. Now let's look at another case that was held in the common law. This case was Market Investigations Limited versus Minister of Social Securities in 1969, per Cook J. The Lord Justice said, control can no longer be regarded as the sole determining factor, and that factors which may be of importance are such matters as the man performing the services provides his own equipment. Did you see that? We'll still continue with the bits of the definition in there. So in this case, Cook, the justice in the matter, said that we cannot just be looking at control. Why? Because sometimes there are happenings between an employer and employee that it will be difficult for you to just quickly label it control in a strict sense. Let's take, for example, a doctor, a surgeon who is working in the hospital. Are you sure the company or the hospital staff or the corporate institution where the doctor works is directly responsible for how he particularly and carefully conducts his surgery? Are you sure that is the case? So you realize that in some kind of specialized fields, the first definition that says that the master is the one who generally commands or supervises the manner in which the person does his work may not necessarily lie in cases where there may be some bit of specialized skills. That is why in this particular matter of market investigations, the definitions being given by Cook J is of importance. And he mentions that there are some considerations that we need to look at. One of them, he said, the person, the employee, the one that we hope to call a servant. The things that he does he do it with his own equipment? Who provides him with the tools for the things he does? So that is one of the considerations that we mentioned. Let's look at the second consideration that Cook J mentions in the market case. He says whether he hires his own helpers. It goes on, what degree of financial risk he takes, what degree of responsibility for investment and management he has. Did you see that? So Cook J goes on with other 3 points that helps us to also understand how to establish the nature relation in a vicarious liability test. He's saying that this employee or this person whose actions out of which we are trying to establish a vicarious liability against his employer, we are saying that how does he employ people, or how does he have helpers who help him to do his work? So if, let's say, there is a business and the business now gives a portion of their activities to another group of persons to work, the question is, those persons who are working, who is, for example, providing their remuneration? Okay? The financial risk that is involved, who is caring for that? Who is having substantial control over the management and also investment in that particular activities of the second party? So the case that Cook J mentions opens our eyes to the range at which we can establish the master-servant relation. So hence the position of the law is this. When we want to test for vicarious liability, the first one is the nature of the relationship. It may either be direct, where you have a strict master-servant, that is the person directly controls, or there may be some form of an indirect control, that is the person or the employer will have some kind of substantial hand in the way some general operations go about. In any of those two cases, we can say that we have an effective control system in there. And when that establishes, the idea of vicarious liability will lie. So, for example, if you're a student and you may be taking an examination, if a problem is being tested in tort and it borders on vicarious liability, the first thing that you need to look out for is the nature of the relationship between the person between the employee and the employer, or the supposed employee, or the purported employee and the purported employer. Okay, you need to look at it. Look at the facts. Ask yourself, is there anything in the facts that establish direct control? That is, A is controlling the manner in which B is doing his work. Or you ask yourself, is there anything that shows that maybe A may not directly be having control over B, but in certain substantial and key duties that B performs, he is subject to the control of A. Either of those two situations may establish what is required to prove the vicarious liability element in there. Now, a famous Ghanaian case, a common Ghanaian case that we want to refer in trying to establish the nature of relationship, the nature of the relationship requirement for vicarious liability is the case of Ajuk Yakubu versus Pro Credit Savings and Loans. That was a reported case. These are some of the facts. You know, Ajuk Yakubu was the owner of a Kia truck. Now, this Kia truck was being driven by one of his drivers. Now, somewhere around Pukwasi, the APC junction here. Now, the Kia truck had an accident or was involved in a collision with another car. Now, this car had the Pro Credit Savings and Loans crest emblazoned on the side of it. Okay, so the presumption was that the car belonged to Pro Credit Savings and Loans. So many of the people, or the car that belonged to Ajuk Yakubu, who was the car owner, though he was not the driver, it got damaged. And Ajuk Yakubu took the matter to court. Now his claim was that he wanted to hold Pro Credit Savings and Loans Company vicariously liable for the accident that had been caused by the driver of the car that had the Pro Credit Savings and Loans emblazoned on it. One of the requirements, as we said, that had to be proven in court was that the driver in the car, what was the nature of the relationship between he and Pro Credit Savings and Loans? So this is where the requirement came in. The court, after thorough assessment of the evidence that was preferred before it, said that there was no proof of control between the driver in the car that had a pro credit as against pro credit company. Why? Because pro credit apparently had a program, and the program was what they call the work and pay. So people come, they take the cars, they fund for the payment of the cars, then the people just reimburse pro credit over time. So the driver who was in that pro credit car was not employed by pro credit, and pro credit couldn't have also known at that material time that that driver was also in the car. So they didn't actually exert control or didn't have any kind of indirect control over the driver. Hence, the test of the nature of the relationship between the driver and pro credit savings and loans failed. What therefore do you think would have happened to the ultimate claim of Ajuk Yakubu when he sought to fight for the vicarious liability in there? It failed. So guys, the point is this. If a third party has suffered a tort and is seeking to vicariously hold the employee, the first requirement is that it has to be proven that the nature of the relationship between A and B, the nature of the relation between the purported employee and the purported employer is actually a master-servant relation, where there is either a direct control of the affairs of one party or an indirect yet substantial control over key aspects of the work. When that is done, you have succeeded in proving the first element of vicarious liability, as in the nature of the relationship established. This is sometimes what we sometimes call a contract of service. When there is a master-servant relation where A controls the activities of B, we say that it is a contract of service. That is what usually happens in there. So we are done with the first test. Let's look at the second requirement that you have to establish if vicarious liability has to be proven. The second requirement is cause of employment. I refer you at this juncture to the case of the Attorney General versus Daddy. It was held in 1971. One of Ghana's most venerable quorums, Justice Azukra, Justice Apalu, and Justice Jagi, sat on that matter. Now, these were the facts that were established in the Attorney General versus Daddy case. Now, Mr. Daddy had a car. He was driving somewhere around the Winneba Accra Road. What happened was that his car got crashed or mangled by a fire service tender or a fire service truck. So what happened was that the fire service car, or Mr. Daddy's car, was subsequently moved to the fire service warehouse where they had offered to repair the car for him. Over months of delay where he saw that they were not repairing the truck, he took fire service to court. Of course, because it is a state agency, he had to bring the matter to court through the Attorney General. At the court of first instance, the court held for Mr. Daddy that it was a fire service driver whose negligence had caused Mr. Daddy's car to be mangled. The Attorney General, acting on behalf of the state, who was obviously not satisfied by the results of the judgment, took the matter on appeal. So on appeal, something had to be established. The first requirement was, okay, that is, by the nature of the relationship, the driver whose carelessness or negligence had caused the accident was, of course, an employee of fire service and hence the state. No problem about that. But the second requirement that leads us here is that the cause of employment. Guys, the point is this. For vicarious liability to be established for any particular tort, the wrongdoing that is alleged or the tort that the person seeks to find his claim on should have been committed in the person's course of employment. So in the Attorney General versus Daddy case, Chief Justice Apalu gave a very powerful quotation. In 2-point quotations, we get a sense of what we mean by course of employment. Let's see the Venerable Apalu in Attorney General versus Daddy. By court, was the second defendant doing something that he was employed to do? If so, however improper, either negligently, fraudulently, contrary to express orders, the master is liable. Did you get the first points from the case? Justice Apalu said that the act that led to the tort was the servant doing it as a result of an employment. Like, what happened? Okay? Was it something that he was employed to do? If it was something that he was employed to do, then the master is liable, even if the person did it fraudulently or negligently. So the question for the court on appeal was that this driver of the fire service tender, whose negligence had caused the accident and therefore the damage to Mr. Daddy's car. At the time that the accident happened, was he doing something that was within his scope or course of employment? Now, before I come to the actual facts of the case, again, in the conclusion, let's look at the second part of the quotation that Justice Apalu also said. If, however, the servant is not doing what he is employed to do, the master doesn't become liable merely because the act of the servant is done with the master's knowledge, acquiescence, or permission. You get that? So Justice Apalu, again, the court mentions the other side of the coin, which says that if, however, what the servant is doing was not what he was employed to do at that material time, it was not involved in the scope of work, then the master does not become liable. Now, let me tell you what happened in the Daddy case. You know, the fire service driver was required to park his car around 5 or 6 p.m. at the fire station. He decided that before he was going to park his car out of working hours, he was going to do a quick dash to a wake-keeping ceremony or a funeral in his hometown somewhere around Winneba. Then make that quick dash and come back to Accra and park the car. So 2 points were apparent in there. The time that he was with the fire service tender, or he was fire service truck, the office hours or the time that he was supposed to work had already closed. He was not supposed to be driving the car at that time. He was not supposed to be on the Winneba Road at that particular time. In fact, his work schedule didn't include he, the driver, having to have the fire service truck running around the Accra Winneba Road after 6 p.m. or 7 p.m. or 8 p.m. So the position of the court that is in tandem with these quotations is that the time the fire service driver was moving the truck, was it done within the course of his employment? The answer was no. So the court held for the Attorney General that, true, it was a master-servant relation, but because the wrongful act, because the tort was not committed during the course of his employment, vicarious liability was failed or could have been said to have been failed to be established, and therefore they couldn't hold the government responsible for the acts of the driver. If Mr. Dade had any claim, that claim had to be directed towards the driver personally, but his employer could not be vicariously liable. Guys, the point is clear. So a very key phrase that is always used in vicarious liability is, if the person was not in the course of what the tort was not done in the course of his employment, we will say that the person was on a frolic of his own by Baron Parker. A frolic on his own simply means that he was doing something that was totally unconnected to the scope of his work. He was doing something that was not related, irrelevant at the material time of the tort to his work. When these conclusions are established, we say that it was either it was done in the course of his employment or he was on a frolic on his own. If it was on his frolic on his own, the question is that, or the answer simply is that vicarious liability cannot be established against the employer. Now, in Wilson versus Jolowicz, one of the most authoritative writers on the Book of Tort, they give us some bit of indications, some qualifications, some criteria that we can also use to assess what we mean by course of employment. A couple of them are these. The first point, the act he is doing when he commits the wrong will be within the scope if it has been expressly or impliedly authorized by the employer. Guys, did you get that? So we are saying that according to Jolowicz, the authoritative writers on torts, they give some indications that if the act through which the tort emanates was a result of an express or implied directive from the master, we say that it was done in the course of his employment. So I'll give you an example. Nowadays, sometimes when you go to the bank, you realize that when someone is attempting to fill a deposit slip, the private security persons who are there, they sometimes just go try to give the person a hand in helping the person to fill the deposit slip. The question is that who is authorizing them to do that? Even if it is not an express authorization from the bank manager, the fact that the manager is aware or the bank is aware that these private security persons are helping people to fill their deposit slip is an implied authority. Because if someone has a problem with the slip, who does he go to? He doesn't walk to the teller. He walks to the private security person to ask for assistance and helps him to fill that. The question is that, the point is that if something should arise if a wrongdoing should arise, if a wrong transaction should arise out of that action, the bank cannot say that the private security person is not their worker, and therefore the customer who has suffered a wrongdoing because of the actions of the private security, they are free. They can be held vicariously liable. So that's the first point. If the act is either by an express or implied authority by the employer, vicarious liability could be established. The second point in here, the act should be within the scope if it is necessarily incidental to something which the servant is employed to do. You get that? Again, the act will be said to be within the scope of employment if it is necessarily incidental to what the employee was employed to do, or what the person was employed to do. Necessarily incidental. Ladies and gentlemen, the point is this. If the wrongdoing is something that will have been reasonably arisen out of the general duties that was assigned the employee, if something comes out of that, the employer could be vicariously liable. I'll give you an example. Let's take the radio stations or a media house. If a media house hires someone to do a morning show, on his morning show, the person is supposed to conduct an interview, right? Good. Now, if the person is conducting the interview, one of the necessary or the incidental consequences is that someone will probably call into the program, or during the course of interview, a defamatory statement may be made about a third person. True or false? Now, that should be reasonably anticipated in that radio interview, that someone may say something that may possibly defame a third person. So if a defamatory statement comes out and a person outside who feels defamed by that action decides to hold the radio station vicariously liable, the radio station cannot say that, oh, I didn't know that. Why? Because that defamatory statement that was let out on the morning show was an incidental act from the duties that was assigned to the radio show host. You okay? So this can also constitute a tort that has occurred in the course of employment. Let's look at the third point. Again by Jolowicz, the injury done by the servant must involve a risk sufficiently inherent in or characteristic of the employer's business that is just to make him bear the loss. You saw that. It says that it is sufficiently inherent and characteristic of the employer's business such that it is just that we allow the employer to bear the loss. If someone, for example, has a restaurant business, you know one of the risks that can happen? If food that is being prepared in the kitchen is not properly taken care of, it could result in food poisoning. So if an employee, probably some of those cooks or the chefs who are in the kitchen, makes a mistake out of an unclean hand or some other unsanitary conditions and drops some bit of dirt into someone's food, and someone goes to the restaurant and the person eats, less than 30 minutes or within a certain reasonable time, he begins to have a massive stomach upset, some kind of abdominal stress. The restaurant owner can say that, oh, we were just serving, we didn't even know that this was what has happened in the kitchen. No, because once you are running a restaurant, you should know that the risk of food poisoning is reasonably connected, right? It's reasonably connected or inherent in that nature of business. And therefore, if a matter arises out of that, the employer can be held vicariously liable. You know, recently here in Ghana, there was a company. Now, this company was involved in the making of explosives, right? Now, in one of their usual courses, the driver or one of the trucks that was supposed to transport the explosives had to drive through a town somewhere in the western region called the Apiati. Now, as he was going there, something happened. He got crossed by, I think, according to the story, a motor rider or an obstacle. And there was some bit of fuel leakage. And through the fuel leakage, there was an explosion. The explosion brought down a whole community. Now, the question is, can that company be held vicariously liable? Of course they can. Why? Because they should understand the risk that once your business involves the transportation of explosives through a community, there is always bound to be the possibility that there's going to be an explosion. So once the explosion hits you cannot excuse liability. And of course, in that story, I think eventually the company had to make some restitutions to government. So guys, we get it. In this point, you're trying to say that the cause of employment, what the person does, if you can reasonably link it to his work schedule, or his work itinerary, his job description, the employer can be held vicariously liable. So, ladies and gentlemen, guys, friends and colleagues, students, I believe by now we get a sense of what vicarious liability is. We are basically trying to say that if A, by virtue of relationship with B does an act or a tort that affects C can hold A vicariously liable for the acts of B. And we have given you the test. The test is true. 1, the nature of the relationship between A and B, master-servant relation, an employer-employee relation. It should be one of an effective control or direct control, or an indirect one, either case. 2, the tort that we are alleging, or the tort that is said upon which the vicarious liability is being leveraged on, should be of such a nature that it should have happened within the course or scope of employment. Now, to condense all these points, I'll take you to a very interesting recent case at the Court of Appeal. The case is Prudential Bank versus Appiah Boateng. That was reported in 2018 or in 2019, the Court of Appeal reports. Now, what happened in the Prudential Bank versus Appiah Boateng? Now, Appiah Boateng, a member of parliament in Ghana, had an account with Prudential Bank in one of his branches. Now, because of his busy schedule, the manager at Prudential Bank, that's the branch where Appiah Boateng was, where Appiah Boateng held an account, told him that, look, because of your busy schedule, you're always directing people to come around to take money. Why don't you just, for example, sign some blank checks and hand them over to me for safekeeping? Said that if, for example, you need anyone to come for money, you don't need to drive out of your own busy schedule and come to the bank. You just place a call. I just take one of the checks that you have signed. I just fill the amount in there. Then I give it to the fellow. The person takes the money away. Appiah Boateng felt it was a good idea because as a member of parliament, obviously, he was very busy. Now, it later happened that he discovered that there were some transactions or withdrawals from his account, which he, Appiah Boateng, had not authorized. He complained about the matter, and investigation was launched. It came to the realization that the very manager whom Appiah Boateng had entrusted into his custody, his checkbook, was the one who had surreptitiously taken some of the checks and pulled some of the money out and given it to other people or for some other businesses. So Appiah Boateng took the matter to court and decided to hold Prudential Bank vicariously liable for the acts of his own manager. The trial court, that is the High Court, found for Appiah Boateng and said that truly Prudential Bank was vicariously liable. Prudential Bank was dissatisfied by the High Court judgment, and therefore they appealed to the Court of Appeal. In a stunning and legally resonant statement delivered by Justice Kusi Appiah at the Court of Appeal, the Court of Appeal summarized all that we've discussed and gives us the current position of Ghanaian law on vicarious liability. This is what the court said in Prudential Bank versus Appiah Boateng. A master is not responsible for a wrongful act done by his servant unless it is done in the course of his employment. It is deemed to be so done if it is either A, a wrongful act authorized by the master, or B, a wrongful and unauthorized mode of doing some act authorized by the master. In other words, a master is responsible not merely for what he authorizes his servant to do, but also for the way in which he does it. If a servant does negligently that which he was authorized to do carefully, or if he does fraudulently that which he was authorized to do honestly, or if he does mistakenly that which he was authorized to do correctly, his master will answer for that negligence, fraud, or mistake. That was a very powerful and instructive statement by the learned justice of the Court of Appeal. You saw that. So the master will be liable for the fraud, negligence, or mistake if the action was done in the course of his employment. ladies and gentlemen, this is the whole idea about vicarious liability. Let me hasten to add that, from our definition that we have given, anytime there is a tort, vicarious liability can be attached to that tort. That is, if there is a master-servant relation in there. So if there's a tort of trespass, and someone authorized that trespass, apart from damages being sought against the individual, vicarious liability can also be brought against the employer. If there's a tort of defamation, apart from the tort being found or being an action in defamation being brought against the tortfeasor, that is the person who did that, we can also hold the employer vicariously liable, be it the radio station or etc. So bear in mind that out of all the torts that you keep learning, always try to look for opportunities where, if the situation arises, we can have the attachment of the principal to it. And that is what vicarious liability does. I think you understand what we've discussed.